Right. Well, good morning. Good morning, or good morning again to those of you who've been on since the couple of minutes ago. I'm Andrew Singer. I'm the head of the construction team here at King's Chambers. I'm also head of King's Chambers, and I'm going to be speaking to you this morning for about 20-25 minutes about collateral warranties and the recent decision of the Supreme Court in a case called Abbey Healthcare. So the first thing I'm going to be discussing is a little bit of content, because I appreciate that whilst this is a construction series, it may not be everybody's bread and butter. So the first question is, this case concerns the dispute resolution procedure known as adjudication, which is a construction dispute resolution procedure, and it's bespoke effectively to the construction industry. It was introduced in the 1996 Housing Grant Construction and Regeneration Act, which has subsequently been amended, but the amendments don't matter for the purposes of today. And under that act, the legislature introduced a statutory right to adjudicate any disputes arising under construction contracts as defined. As the Supreme Court themselves said in the Abbey case, statutory adjudication is an expeditious and cost-effective dispute resolution procedure, typically before a trained adjudicator who's a specialist in construction-related work. It results in legally enforceable decisions which are binding on the parties unless until there's a final determination by arbitration, litigation, or agreement. So specifically, construction adjudication was brought in to try and assist in stopping a practice which was inelegantly known as subbashing, where the final payment to a subcontractor or even a main contractor would simply not arrive. By the time the subcontractor or main contractor had got to court and got through processes, if they could afford it, they were either in liquidation or simply took a very small amount of money because they had to get some cash. It was an attempt to keep cash flowing through the industry. It's a paper-only 28-day exercise, which results in a legally enforceable, through the courts, through summary judgment, as we'll see, decision, which is binding, but temporary binding. So you get the cash now and you argue later. So construction adjudication was brought in to assist with payment disputes, basically, although it applies to all disputes between parties under a construction agreement. It was mainly brought in for payment reasons. But it also provides a very swift way of dealing with construction disputes, which otherwise, as some or all of you will know, can last a very long time and cost huge amounts of money. So that's broadly what construction adjudication is, and that's what we're talking about here. It's quite often the first, and in many cases the only step in construction dispute resolution. If you're unhappy with adjudication, or you simply don't go to adjudication, there's obviously litigation and arbitration. This case is about whether parties can adjudicate under something called a collateral warranty. Now, why do parties need a collateral warranty? Adjudication is obviously a process for claims under a contract. A collateral warranty is obviously a contract, but it's, as you I'm sure know, a different form of contract. It's a warranty that's provided, again, as the Supreme Court tells us, to third parties, namely funders, purchasers, and prospective tenants. In this case, it was a tenant. And the reason why people have collateral warranties is because of the decision in the House of Lords case of Murphy and Brentwood in 1991, that third parties could not claim in tort for third-party loss, for economic loss caused by defects or other failures in the building process. So, in other words, if you didn't have a contractual route to normally the contractor or the subcontractor, you have no chance of claiming for your losses in tort. You had to claim in contract. And so it's very common. Those of you who are contentious and non-contentious lawyers probably spend some of your time drafting these warranties, and after the Abbey Care case you're probably spending more of your time drafting them or trying to in a different way. So, but parties need a collateral warranty because without one, they will very likely not have a claim against in tort for losses. They give claims normally in respect of defects. This case was a case about defects, as we'll see. And the whether a collateral warranty was a contract, construction contract, which allowed parties to have their disputes about defects heard at first instance as an adjudication. So that's the context to adjudication: quick, temporary binding, 28-day. Warranties, why do we need them? Because otherwise third parties to the contract, the building contract, wouldn't have a claim. So what's the background briefly to the Abbey Healthcare case? Well, in Abbey Healthcare, there was a collateral warranty. That was executed 4 years after the original works were completed and after remedial works had been carried out. And the remedial works were not carried out by the original contractor. They were carried out on behalf of the developer, the owner, and in fact, the tenant. And after that, there was a SPAT, as you would expect. And the first thing that happened as a result of the SPAT was that a collateral warranty was executed. And Abbey, who were the tenant of this building, which is a care home in London, Abbey brought an adjudication in respect of the remedial works, as did the developer. Now, the developer obviously had a contract with the builder, and there was no question that that was a construction a construction contract. But in the adjudication, both of which succeeded, but in the Abbey adjudication, there was a challenge to jurisdiction on the basis that the collateral warranty wasn't a construction contract, because Section 104 of the 1996 Act says that a construction contract is, quote, amongst other things, an agreement for the carrying out of construction operations. Now, the adjudicator said that the collateral warranty was an agreement for carrying out of construction operations, and he therefore found he had jurisdiction because it was a construction contract, and found that the award and made an award in favour of Abbey. The contractor didn't pay, so the usual enforcement proceedings were brought in the TCC, and that is a case called Topham Holding and Abbey Healthcare. It's the first part of this case, and in the TCC, the judge refused to enforce it. He did obviously enforce the first adjudication, but he refused to enforce the Abbey adjudication because he said that the warranty wasn't a construction contract. In the Court of Appeal, 2-1, the leading judgment being given by Lord Justice Coulson, who many of you will know is the leading progenitor of most of the important cases on construction adjudication, and it's been probably more than anything else responsible for its success as a dispute resolution process, for the courts making it a success by being pro-adjudication. He said it was a construction operation. And one of the reasons why he said that was because he relied on a much older case that had been decided by Mr. Justice Aikenhead, which was a case called Parkwood from 2013, which first said a collateral warranty could be a construction contract. One judge, Lord Justice Stuart Smith, who's also a construction specialist, said he wasn't, agreed with the judge, but 2-1, it was a reversal. And then the matter ended up in the Supreme Court, and their judgment came out in July, and it's 2024 UKSC 23, and they unanimously reversed the Court of Appeal and reinstated the judge's decision. Now, what did the Supreme Court decide, and why did they decide it? Well, The first thing it's probably helpful to consider is what the warranty actually said. I've already told you that it was entered into well after the contract works had been completed, and actually after the remedials had been completed. But this was a warranty that A, the contractor has performed and will continue to perform diligently its obligations under the contract. B, in carrying out and completing the works, the contractor has exercised and will continue to exercise all the reasonable skill, care and diligence to be expected of a properly qualified, competent and experienced contractor, experienced in carrying out and completing works of a similar nature, value and complexity and timescale to the works. And C, there's a similar warranty in respect of design. 4.2, insofar as the contractor has performed a part of its obligation under the contract before the date of the contract, the obligations and liabilities of the contractor under this agreement shall take effect in all respects and if the contract had been dated prior to the performance of that part of its obligations by the contractor. So these are all ongoing and retrospective obligations. That's the warranty, and that is a relatively common form, as you probably know, of warranty wording in these types of matters. So the Supreme Court, having recited, as they do of course, and explained where the judgments came from below and where the particular judges arrived at their decisions and why, and referred also to the Parkwood case. And they then, at paragraph 56, analysed what the issues were between the parties that needed to be determined on the appeal. And there were two issues. One, statutory interpretation. What is the meaning of an agreement, quote, for the carrying out of construction operations, close quote, in section 104.1 of the 96 Act. And remember, I showed you that on the previous slide. And then a contractual interpretation of how should the Abbey warranty be construed. And so construed, is it an agreement for carrying out construction operations? And so the first issue was the statutory interpretation. What does the law mean when it talks about an agreement for the carrying out of construction operations? There was a great deal of discussion, both in the Court of Appeal and in the Supreme Court, about what the word for meant, and whether it meant in respect of, or whether it meant more than that, purpose of. And there was debate in the Court of Appeal between Lord Justice Coulson and Lord Justice Stuart Smith about that, and whether there should be a broad or a narrow interpretation of the statute. But ultimately, said the Court of Appeal, as a generality, Supreme Court said, as a generality, it's difficult to see how the object or purpose of a collateral warranty is the carrying out of the construction operations. The main purpose of such a warranty is to afford a right of action in respect of defectively carried out construction work, not the carrying out of such work. Whether or not, this is paragraph 66, whether or not the carrying out of construction operations has to be the main object or purpose of the agreement, it must surely be necessary for the agreement to give rise to the carrying out of such operations. A warranty that merely promises that the operations undertaken will be performed doesn't do so. In such a case, it's the building contract gives rise to the carrying out of construction operations, not the collateral warranty. Any obligation undertaken to the beneficiary to carry out construction operations derives from or mirrors the obligation already undertaken under the contract. Everything is referable to the contract and replicates duties thereunder. There's no distinct or separate obligation to the beneficiary. There's no promise to carry out any construction operation for the beneficiary. Merely a promise to the beneficiary that the construction operation to be carried out for someone else under the building contract will be performed. And then they said at paragraph 70, for all these reasons, the collateral warranty will not be an agreement for the carrying out of construction operations for the purposes of section 104.1 if it merely promises to perform obligations owed to someone else under the building contract. There needs to be a separate or distinct obligation to carry out construction operations for the beneficiary, not one which is merely derivative and reflective of obligations owed under the building contract. This is what I understand Stuart Smith J. when he speaks around his judgment of the need for a direct contractual obligation. This does not prevent the collateral warranty overcoming the difficulty arising from Murphy and Brentwood. So, two points here. First of all, a warranty in the usual regular form is not going to be a construction contract. It's just a contract to perform obligations owed to someone else under the building contract. And therefore, you can't adjudicate, but you can still bring proceedings in court or arbitration, depending on what the dispute resolution clause, if there is one, says about that. You still have your right of action, you simply don't have a statutory right of adjudication. So it's not saying that collateral warranties are useless, it's saying that you can't use them to adjudicate. So that's an important point. And then on the contractual interpretation point, which strictly speaking probably didn't arise on the statutory interpretation, but in any event they decided it. Paragraph 73, they said, on the approach of the majority, any collateral warranty which contains a promise in materially similar terms to clause 4A, which I've read out before, will bring the agreement within section 104. This will be so even if, as in this case, all construction operations and remedial construction operations have already been performed at the time of execution of the warranty, so there's no issue as to future or continuing performance. I don't consider that these few words can bear the significance which the majority place upon them. As I was saying, to be fair, although the Supreme Court made the point that it needs to cover future, that the words need to cover future obligations, future and past and future performance, as I say in paragraph 73, actually it does cover, it does talk about future performance in terms, but in any event. What the Supreme Court then say is a far more principled and workable approach is for the dividing line to be between collateral warranties, which merely replicate undertakings given in the contract, and those which give rise to separate or distinct undertakings for the carrying out of construction obligations. That is the distinction which can be easily understood and applied. Adopting such an approach is likely to mean that most collateral warranties will not be construction contracts. There are, however, good reasons for concluding that in general such warranties were not intended to fall within the scope of the Act. In particular, aside from the reasons given, it's notable how the various payment-related provisions of the Act are simply inapplicable to collateral warranties, since the consideration provided is typically nominal. Further, it follows that one of the twin purposes of the Act, improvement of cash flow, is not furthered by its application to collateral warranties, unless stepping rights are exercised. The beneficiary has no construction operations. It's also in the interest of certainty there's a dividing line, which means that collateral warranties are generally outside the 96 Act rather than everything being dependent on the wording of the particular warranty issue that will assist those in the construction industry and those advising them to know where they stand. Moreover, if it is wished to have a right to adjudication, that can only be provided for. Adjudication will, however, be voluntary rather than mandatory. So, and then the final thing that the Supreme Court did was, when they went away to think about their decision, their judgment, they looked again at the Parkwood case, which the Court of Appeal had relied on. And they said that, in their view, having asked for further argument, that Parkwood was indistinguishable on its facts and on the judgment from the decision of the Court of Appeal in the Abbey case, and they therefore overruled Parkwood. And in doing so, again, with all due deference to a very experienced TCC judge who was there, the judge in charge of the list for many years, and the fact that it was decided 10 or 12 years ago, which in the context of adjudication is a long time. Nevertheless, they did overrule Parkwood, and they did point out that the current manual of construction agreements says that the decision in Parkwood was received with dismay by some commentators, one of whom described it as simply wrong. Substantially on the grounds canvassed in earlier editions of the title and on the ground it misstates a derivative obligation for a separate construction contract, which plainly it was not. The Supreme Court said there are principled and practical grounds for overruling the decision and reverting to the position as it was generally understood before Parliament. This allows parties to contract into the regime where it's desirable, but not be fixed with an inability to contract out. And therefore they allowed the appeal, and the adjudication decision was not enforceable. So the legal consequences and practical consequences are, firstly, under normal circumstances, you now cannot take adjudication proceedings if you are the beneficiary of a collateral warranty, unless that warranty has in it, in terms, a separate agreement to adjudicate. And that will be an agreement made between the parties. That wouldn't be a statutory adjudication, it will be a contractual adjudication. Now, as you all know, lots of the main forms of building contracts have contractual adjudication provisions which normally comply with the statutory scheme. And it may well be that in the future, one thing that will happen is that collateral warranties will themselves have an adjudication provision in them, so that the parties can adjudicate if they wish to. That will be a matter for negotiation. It may be that insurers are not keen on that, and the reason I mention insurers is because quite often the warranties are aimed at getting at somebody's insurance, and that tends, as those of you who work with providers of warranties will know, need to be insurance backed. Insurers might say, well, actually, we prefer not to be subject to adjudication. Thank you very much. So we'll have to see how that goes. But the legal and practical consequences at the moment are the same. They are that you can't adjudicate under a collateral warranty unless it's in a particular form, which is going to be much more detailed than the current provisions. And frankly, the safest way to adjudicate would be if you actually had an agreement to do so. I don't know if there's any questions that anybody wants to ask. There's one from Anonymous. Where the warranty has step-in rights in the standard form, will the step-in rights result in the warranty being regarded as a building contract? Or is the case only, well, okay, so I don't think that simply having step-in rights, that means that you're entitled, if the contract work stopped before the contracts, work stops before the end. Sometimes funders or tenants can step in and finish the work themselves. I don't think that will mean it's a building contract. I think you need to have express words that make it clear that it is a construction contract. But it might have been a slightly better argument, but I don't think that's the end of it. And then, so just, sorry if I didn't make this clear, if you include a right to adjudicate within, that will cover it, yes. That will cover it, provided it's a valid adjudication provision. And I don't suppose there's any reason why it won't be. If there is a contractual adjudication process, then that will be upheld. Quite often, for example, as some of you will know, there are contracts which are excluded construction operations, which don't fall within the 96 Act at all. For example, on a domestic house, but quite often you'll find that parties have entered into a JCT contract which has an adjudication provision in it, and that does bind the parties, even though the statute doesn't. So yes, and as the Supreme Court themselves said, it allows parties can contract into the regime where this is seen to be desirable. But the problem would have been if they had said that the collateral warranty was a construction operation, then the Act does not allow you to contract out, and therefore you would have been stuck with an adjudication whether you wanted to or not. The contractual route is at least also not just contractual, but also on the basis of an agreement between the parties. In other words, consensual. Thank you very much for your time this morning. I hope it's been helpful. Thank you for attending. Please sign up for the next seminars in the construction series that we're running here at King's. And I wish everybody a good rest of the day. Thank you very much.